This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows.
Voice 1. The courtroom was thick with tension as the judge's gaze swept over the accused, sharp and unforgiving, and he began. Let me be crystal clear, this court operates on zero tolerance. Absolutely zero. We have had one issue after another testing positive here, failing to comply there. Excuses piled on excuses, and yet the pattern continues. We have literally let you go over and over, and now we are past patience. There is no excuse for these missed blows, and any attempt to rationalize them falls flat in the face of the rules. The accused shifted nervously, his palms sweaty, fingers twisting, eyes flicking from the judge to the probation officer, trying to gauge if any mercy lingered in the room. His temporary lawyer, standing in for the lead counsel, tried to interject, voice respectful but urgent, pointing out that the accused had maintained a clean UA record, had no positive tests, and that perhaps the court could defer consideration until the lead attorney returned. Yet the judge's glare silenced the plea immediately, a cold reminder that principles, not excuses, govern this chamber. The accused swallowed hard, voice trembling as he raised it, desperate, promising compliance in every way imaginable, offering ankle monitoring, extra testing, anything at all, pleading for a single chance to stay free, to prove his commitment, to show that he was trying, really trying, to follow the rules. The room felt almost electric. Every breath seemed amplified. The shuffle of papers, the tapping of a pen, the faint creak of leather chairs marking the rhythm of accountability. The probation officer leaned forward, a solemn record of responsibility in hand, quietly noting the seriousness of repeated missed tests, while the judge's voice cut through like steel, warning that rules were not negotiable, that each missed test was a violation, and that the next slip would carry consequences severe and unavoidable. The accused's chest heaved with fear and frustration, his thoughts racing. He hadn't drank, he hadn't used substances, he had been trying, but the missed tests, the relentless tally, hung over him like a storm cloud. He tried to plead again, this time more passionately, words tumbling out in a jumble of remorse, hope, and fear, but the gavel struck sharply, echoing through the chamber, a sound that seemed to freeze the very air, commanding attention, respect, and fear all at once. And in that heavy silence that followed, the judge leaned back, voice calmer but no less firm, reiterating that while effort was noted, it did not erase responsibility, that justice in this court was deliberate and exacting, and that mercy had limits, patience had bounds, and accountability was absolute. The accused lowered his eyes, a shiver of anxiety running through him, understanding at last that he was on the edge. Every choice, every action from this moment forward would be scrutinized, every missed test a mark against him, and that the court, impartial and relentless, had already made it clear there would be no further tolerance, no more chances, and every misstep would be met with the full weight of the law. Yet beneath that fear flickered a small ember of determination. Perhaps, if he truly committed, followed every rule to the letter, if he could navigate the exacting standards of the court, he might still walk out, not with freedom guaranteed, but with a path to redemption, hard-earned, tense, and uncertain, every heartbeat echoing the courtroom's silent demand for perfection, obedience, and unwavering accountability.
They're saying they have a marijuana charge they could have done. Is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're 0.1 mile away from the location. For what?
Well, okay, I get that, but so we have what we have. We've got a disturbance at HEB. Cops go there. Okay. They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have.
Okay.
Right? Mr. Zenon, there's always two sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else. Was there another warrant that you said?
It's the aggravated assault, but Judge, I also would like to point out that
But they end up putting him in the car, and at that point, he basically just goes plank like this for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because I mean, there's no.
Voice to the court session began with tension hanging in the air as the prosecutor raised a critical point about the defendant, Mr. Zenon, and his recent interactions with law enforcement. The judge listened intently as it was explained that the defendant had just picked up a new interference case, and the matter needed careful review. Mr. Zenon had been on felony probation for a serious charge of evading arrest in a motor vehicle, a crime carrying up to 10 years in prison, and now he was facing additional scrutiny for his recent conduct. The discussion highlighted that, during a disturbance at a residence, officers had attempted to intervene after multiple 911 calls reported an argument and threats, including the defendant stating he would slap the complainant. When officers tried to take him into custody, the defendant resisted, refused commands, and actively impeded the arrest, pressing against the officers and using his legs and feet to prevent placement in the vehicle. Witnesses confirmed his aggressive behavior, including threats and physical pushes. The legal team debated whether this behavior qualified as interference with public duties, noting that he was resisting arrest but not necessarily obstructing other law enforcement actions. The judge and attorneys reviewed the relevant statute, which criminalized any person who, through negligence, interrupts, disrupts, impedes, or otherwise interferes with a peace officer performing their duty. The discussion emphasized the vagueness of the law and the multiple ways a person could be considered interfering, but the main concern remained clear: the defendant's deliberate resistance during an active investigation, compounded by his prior history, was enough to warrant probable cause to move forward. The court noted that Mr. Zenon's actions were serious, highlighting the legal and practical complications of resisting officers during a lawful detention and the ongoing need to determine whether additional charges were applicable. It was a vivid example of how repeated disregard for the law and obstruction of justice can escalate legal consequences, underscoring the court's role in balancing the defendant's rights with the enforcement of public safety duties.
I think so. In this life, you are only as good as the proof that you don't have. If you don't have proof, you have nothing. Spoken word means absolutely nothing.
Voice 3. The courtroom was tense as the judge fixed his gaze on the defendant, his voice steady but firm. "What have you done?" he asked, cutting through the murmurs in the room. The young woman took a deep breath, trying to maintain her composure. I went to a class, and then I tried to go yesterday, but they canceled it," she explained, glancing at her attorney for support. The judge leaned forward slightly, pressing, "And the day before court?" She hesitated for a moment and replied, "I also went before you, Your Honor." Her lawyer quickly intervened, emphasizing, "She has been attending faithfully. She's been going consistently, even for the last 4 sessions. We can prove it with documentation and emails from her instructor." The judge nodded slowly, his expression serious. "You see," he said, "in this courtroom, proof is everything. Words alone mean nothing. Spoken promises do not count. Actions, attendance, and documented efforts are the only things that carry weight here. You must show that you are committed, that you are making real progress, and that your attempts are measurable and verifiable. This isn't just about intentions, it's about accountability, and accountability is reflected in evidence, not excuses. If you fail to show proof, then it's as if nothing has been done." The young woman shifted nervously in her seat, the weight of the judge's words pressing down on her. Her attorney handed over emails and attendance records, showing that despite canceled classes and scheduling conflicts, she had been consistent and dedicated, actively working toward completing her GED. The judge glanced over the documents, then back at her, his eyes softening slightly. "I understand there were obstacles," he said, "and I can see that you've made an effort. That is why the proof is so important. It separates genuine effort from mere words. Your record shows persistence, commitment, and the willingness to follow through, even when things don't go perfectly. Keep going. Keep showing up. If you maintain this pattern, in a few months, you will have tangible results." The court recognizes effort, but it must always be measurable. Do not let your progress stall. Continue attending, continue submitting evidence, and continue proving that you are serious. That is how you demonstrate growth, responsibility, and your dedication to completing your goals. Remember, the path to your get is not just about passing a test, it's about showing this court, and more importantly yourself, that you can commit, persevere, and succeed despite obstacles. The young woman nodded, a mixture of relief and determination in her eyes, realizing that the path ahead demanded not just intent but proof, consistency, and visible progress, and that the court would reward effort only when it could be seen, documented, and verified.